violation of privacy.
ಇದಕ್ಕೆ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳಿಲ್ವಾ ಅವರು?
They're both classmates.
Gen Z lingo. As the petitioner was a state level cricket player and had to then represent a U19 team in Tamil Nadu, describing her to be beautiful, but in a Gen Z lingo. The investigating officer shall forthwith return all the items of the petitioner that are seized and kept in the custody.
Lord, matter pertains to a complaint that has been filed by a college student against her classmate for him commenting on an Instagram post. If I can take my lords directly to the offending messages, allegedly offending messages, 35 ತಾವ್ ನೋಡಿದ್ರೆ.
Snapchat
ಅಲ್ಲಲ್ಲ Instagram. ಏನೋ ಸ್ಟೋರಿ ಹಾಕಿದ್ರಂತೆ. My lord.
Story?
Page 35 my lord.
ಏನಿದು ಪ್ರಿಟಿ?
ಅದಕ್ಕೆ ಅವರು ಥ್ಯಾಂಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಎರಡನೇ ಕಾಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ she has her father is a senior police officer. I don't want to name him. The name is available in the cause list, in the cause title. They have then picked him up, filed an FIR. Then they have impounded his laptop and his phone, and for the last 2 years have kept it in their custody. And they've put up offenses of voyeurism, stalking, ಮತ್ತೆ act to insult the modesty of any woman, and 66E violation of privacy.
ಇದಕ್ಕೆ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳಿಲ್ವಾ ಅವರು?
ಈ ತರ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಥ್ಯಾಂಕ್ಸ್, ಈ ಕಾಮೆಂಟ್ ಗೆ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳಿಲ್ವಾ?
ಇಲ್ಲ ಅದೇ instead of saying thanks, she has asked her father to file an FIR on her behalf. He's a student, my lord. They're both classmates.
Gen Z lingo. Yes.
In fact, while confiscating his laptop and his phone, they haven't followed any procedure. My lords also have observed in several matters that
when a police officer's family is the complainant, nothing is followed. ಯಾರಿಗೆ ಕಳಿಸಿದ್ದಾರೆ? ಇದ್ಯಾವ ಫ್ರೆಂಡ್ಸ್ ಕಳ್ಸಕ್ಕಾಗತ್ತೆ? It's a DM on Instagram. DM on a direct message. Yes. ಏನ್ ತಪ್ಪಿದೆ ಇದರಲ್ಲಿ?
ಇದು ಯಾರಿಗೂ ಕಾಣಿಸಲ್ಲ ಸ್ವಾಮಿ.
She must be happy.
A private chat.
It's a private chat, true. What's wrong with this? That's why I said Gen Z lingo. And served unrepresented. ಯಾಕೆ ಈಗ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಅಲ್ಲೋ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ರ?
ಇಲ್ಲ ಇನ್ನೂ
ಇದಾರಾ? The petitioner, a student, is before the court calling in question the registration of a crime in crime number. Madam,
0363 of 24, my lord. Page 23 ಅಲ್ಲಿ FIR ಇದೆ.
Crime number 363 of 2024 registered for offences punishable under so and so. Stay there.
Stay there.
The petitioner and the who is the complainant?
The complainant is the classmate herself.
The petitioner and the respondent, who are 21 and 20 years respectively, are classmates and have classmates and friends as well. The issue relates to an Instagram chat. The petitioner, in his zeal, communicates to the complainant by DM, direct message, on Instagram with regard to how the complainant looked on a particular day, describing her to be beautiful, but in a Gen Z lingo. The Message is said to have been shown to the father, who the petitioner submits that is an IPS officer. IPS, huh?
ಹೌದು sir.
Is an IPS officer in the state. Trouble crops up to the student. A crime comes to be registered. Crime comes to be registered, and the career of the petitioner is put to jeopardy, as the petitioner was a state level cricket player and had to then represent a U19 team in Tamil Nadu. The crime then is begun, the crime gets into investigation. Arrest ಮಾಡಿದ್ರಾ?
Arrest, unofficial arrest ಮಾಡಿದ್ರು ಹಿಂದಿನ ದಿನ.
Oh,
There is no
unofficial.
record of that.
The
He's been
the
asked to
laptop and the mobile phone of the petitioner were allegedly seized, which the learned counsel for the petitioner submits that completely contrary to law. Be that as it may, the petitioner then knocks at the doors of this court, and this court stays further investigation qua the petitioner. The complainant, though served 2 years ago, has remained unrepresented even today. Therefore, the petitioner and the respondent state are heard. The petitioner heard sounds. The learned counsel appearing for the petitioner takes this court through the documents appended to the petition or the chat, the direct message that was sent to um, the direct message that was sent to the complainant. The learned counsel submits this would not even attract any of the offences as obtaining under section 77, 78, 79 of the BNS. It was two classmates, two friends chatting, describing how the complainant was beautiful. The learned counsel would further submit that if investigation is permitted, it would become an abuse of the process of the law and jeopardize the career of the student, the petitioner. The learned HCGP, however, would put up vehement opposition to any order that would be passed by the court quashing the investigation itself, contending that be it the classmate, he has no right to speak on how beautiful the complainant looks. So would seek investigation into this matter. And dismissal of the petition. I have given my anxious consideration to so and so. The entire fulcrum of the crime for the aforesaid offences revolves around the chat. The chat is not a public chat. It is chat between two individuals, i.e. the petitioner and the complainant. The chat is as follows. The chat described in the language that the students of this day deploy. They deploy without knowing that it could land the petitioner in the web of these proceedings. Beyond this, there is no chat. The chat that has become the chat that has become the fly in the ointment is what is quoted here and above. The offences alleged are section 74, 77, and 79 of the BNS, which would be outraging the modesty of a woman, stalking, and voyeurism. If this chat can lead to all that, it would on the face of it become an abuse of the process of the law to permit investigation on the chat afore quoted, for it to become the ingredients of voyeurism, outraging the modesty of a woman, or stalking, as the case would be. There is neither stalking nor voyeuristic act of the complainant, of the petitioner, nor it would amount to outraging the modesty of a woman. Yes, it is a particular word used is inappropriate, but that is the word that is used by students of this day. Therefore, that cannot become a crime for the aforesaid offences, and permitting further investigation into the case at hand would not only jeopardize a student's career, but also would become an abuse of the process of the law and result in miscarriage of justice. Allowed quashed.
Deeply obliged, ma'am. My lord, there's an IA for direction to
In
release
the,
the,
in the event, in the light of the quashment of the proceedings, the investigating officer shall forthwith return all all the items of the petitioner that are seized and kept in the custody,
deeply obliged,
if kept in the custody. Yes.
deeply obliged.
Next.